Received all discovery in this case, and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Ms. Bravo, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, probation, there's an application in this case. Ms. Bravo, did you review the true bill of indictment?
Yes, ma'am.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Bravo, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Your charge is possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea.
In the Court of Justice, Dora Bravo stands before Judge Stephanie Boyd with a plea bargain in hand, possession of a controlled substance. She expects the usual outcome, probation, a warning, and freedom. But Judge Boyd asks one question that changes everything. Have you used drugs recently? Bravo's answer is honest and alarming. Methamphetamine. Just 24 hours ago.in that moment. Judge Boyd sees past the paperwork. She knows that letting Bravo walk free could mean one thing, relapse, or worse, an overdose. So instead of signing off on probation, she takes action. Bravo is taken into custody. Not as punishment, as protection. 3 years of deferred adjudication. A mandatory TAP evaluation. Immediate referral to felony drug court. This isn't just a sentence. It's a lifeline.
If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering that plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, ma'am.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Bravo, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Ma'am.
According to the plea bargain agreement, punishment is to be assessed at an $800 fine. State recommends community supervision, deferred adjudication. They're taking in consideration 2025 AL005.
During a recent session at the Court of Justice, Judge Stephanie Boyd reviewed the case of Dora Bravo, who appeared with a plea bargain for possession of a controlled substance. While questioning Bravo, Judge Boyd asked whether she had used drugs recently. Bravo confirmed she had used methamphetamine within the past 24 hours. Given this admission, Judge Boyd determined that releasing Bravo under standard probation posed a significant risk. As a result, she ordered Bravo into custody as an immediate intervention. The court granted 3 years of deferred adjudication, mandated a TAP evaluation, and referred the case directly to felony drug court, prioritizing treatment and recovery over routine processing.
470. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there be any such motions?
No, ma'am.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be a TAP evaluation, community service restitution hours, no contact with Roberto Avalos Jr. and JCPenney stores, the life skills course, and the anti-theft course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
State offers states 1 in attachments.
No objections.
All right, State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence.
She walked into the courtroom expecting just another formality. A plea, a signature, a way out. But Judge Stephanie Boyd saw something deeper in Dora Bravo's case. One simple question: have you used drugs recently? Uncovered a truth Bravo couldn't hide. Meth, 24 hours ago. For most, that admission might have led to routine probation. But Judge Boyd knew better. She knew that walking
States Exhibits 1 and attachments, and the court will review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes,
Anything you wish to say on behalf of your client?
we just asked the court follow the recommendation from the state.
All right, are you employed?
Woman.
How do you support yourself?
My boyfriend,
Who is your boyfriend?
Pedro
Pedro who?
Diaz.
And what happened to Roberto Avalos?
What do you mean? What happened to him?
I mean, you were in a car with him. Is he no longer in your life?
No, he's incarcerated, but nobody stated that I was dating him. I was just getting a ride from him, ma'am.
All right. Did you know him before you accepted a ride from him?
Yes, I did.
All right. And how did you know him?
Friend of family.
Do you have any children?
I do.
What are their ages?
He is 15.
And who is the 15-year-old with?
He is with his uncle and his guardian.
And when you're drug tested today, what are you going to be positive for? And what else? Now, that's not just about it. Do you want to get drug tested today? So here's the thing. I am trying to set conditions for you so you'll be successful on probation. In order for me to do that, you need to be honest with me. All right? So if you use before coming to court, that's not a violation of your probation because you were not on probation. So what are you going to be positive for?
Dora Bravo walked into court expecting probation. One question changed everything. Have you used drugs recently? Her answer: meth, 24 hours ago. Judge Boyd didn't just let her go. She ordered her into custody as an intervention. 3 years deferred adjudication. A TAP evaluation. Straight to felony drug court. Not punishment. A second chance at life.
Well, I wasn't with you. So what type of drugs?
The kind that for methamphetamine.
All right. So when's the last time you used meth?
24 hours ago.
Have any family support?
Yes. Concerned, yes.
All right. Who's supporting you as far as someone you can go to help you maintain your sobriety?
My brother.
Your brother?
My oldest brother.
Okay. When's the first time you started using?
In 2017.
Okay. All right. This is what the court is going to do. There's going to be an $800 fine that will be probated. 3 years deferred adjudication. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. There's to be no residing with minors. Take in consideration 2025 AL 005470. There's going to be 100 hours of community service restitution. Once parenting is completed, the community service hours will be deemed satisfied. There's to be no contact with Roberto Avalos Jr., no contact with J.C. Penney stores. Counsel, I'm not going to do the anti-theft course because I think the theft course is related to the drug issues. And I think if that problem is solved, then there'll be no need for the other. But I am going to recommend the life skills course. There's to be regular reporting by Zoom or in person, regular random UAs, in custody. There's to be a TAP evaluation, follow recommendations, and also a referral to felony drug court. Probation is, and field visits, one time per month for 6 months. Probation, is there anything else? All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. We can go off the record. This is why you're going in custody. You are extremely high today. And if I allow you to walk out of here, what's going to end up happening is you're going to use more meth.
No.
And who knows what will end up happening. You may get some bad drugs.
Why couldn't you give me the benefit of the doubt? I just got out on bond. I'm trying to change. I'm doing what I'm.
I know this is going to help you. All right. Thank you.
How long am I going to be gone?
Thank you, counsel. It's to help her.
I understand.
And they should be, a felony drug court will probably be able to see her before the week is out.
Okay.
All right.
In this case before the Court of Justice, Dora Bravo appeared with a plea agreement addressing a charge of possession of a controlled substance, anticipating a standard probationary sentence. During judicial questioning, Judge Stephanie Boyd inquired into Bravo's recent drug use. Bravo disclosed methamphetamine use within the preceding 24 hours. Recognizing the elevated risk of relapse or overdose associated with immediate release, Judge Boyd exercised judicial discretion to order Bravo into custody as a protective intervention. The court subsequently imposed 3 years of deferred adjudication, mandated a TAP evaluation, and issued an immediate referral to felony drug court, prioritizing rehabilitative intervention within the framework of judicial accountability.